Mr. Chairman, we are live.
Thank you. Members, public, welcome to the March 2nd meeting of the Judiciary Committee. We have two bills that we're going to consider today. We're going to take them up in the order of House Bill 85 first, and then House Bill 33 will be second. And Kay, if you're ready for us, we can go ahead and call the roll, please.
Okay. Chairman Crago. I'm sorry, Representative Crago. Thank you. Representative Larson. Representative Oakley.
Oh, excused on Representative Larson, please.
Okay, thank you. Representative Oakley. Here. Representative Provenza.
Here.
Representative Williams. Vice Chairman Washut.
Here.
Vice Chairman Representative Yin.
Here, thank you.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Mr. Chairman, you have eight. You have eight attending and you have one excused.
Thank you, Kay. And Chairman Crago and Vice Chairman Yin, I'll just hand over the reins. Well, it's not that easy. Okay. I was hoping to get out of it. All right, well, welcome. Just a friendly reminder, we have a full room, which is kind of exciting. And then we're also in the hybrid fashion. So we're out there in the virtual world as well. So we'll navigate between the two, and I don't know any particular order I'll go in. So if you want to speak on a particular bill, I'll just know I'm going to try to bounce between those two worlds and do that in the most efficient and logical way that I can. So we'll begin with House Bill 85, unlawful dissemination of an intimate image. And we have our very own, the distinguished former member of this committee and vice chairman of this committee, Representative Stith, who went on to greener pastures to the Appropriations Committee, but we're glad that you've returned to present us with this bill. Thank you, Mr. Chairman. Hear me okay? Is your mic lit, Representative Stith? You have to light that up because then the cameras know where to look.
Mr. Chairman, members of the committee, I present to you House Bill 85, dissemination of an intimate image. The first issue, I think, with any legislation is to determine what problem you're trying to solve. Why are we doing this? As it turns out, Wyoming is one of just 4 states that does not have a similar statute or a statute that makes what is commonly referred to as revenge porn a crime. This bill is designed to fill that loophole, close that loophole, I should say. My experience of this arose out of defending a client who engaged in conduct that people might consider revenge porn, but the county attorney in our community, realizing that there was no revenge porn statute, nonetheless felt something needed to be done. So what he did in that case was charge my client with aggravated blackmail, which was much more severe than this bill would provide, but also ultimately led to failure of the prosecution because what the conduct didn't really quite fit into aggravated blackmail. So this is designed so that we don't have gaps in our law, and designed so that justice can be done. Because I think in that particular case, whereas I felt like I got a good result for my client, the victim may not have felt that way, and the public interest may not have been served. So to walk through the bill, first, of course, we start with definitions. On page 2, I think the interesting definition from lines 5 through 9, the word disseminate, and our current definition here is disseminate means to sell, distribute, deliver, provide, exhibit, post on social media, or otherwise make available to a third party, but shall not include displaying an intimate image in private to the person depicted in the image. And I read all of that in part because that last phrase there, the reason that you have that exclusion, it's an analogy to the law of slander, libel, or defamation, that if you privately make a false statement to someone that would be slander or would be defamation, but if you only tell that person and it's not published anywhere, then you haven't hurt their reputation necessarily. So we have this carve out that merely distributing the image from the person who gave it to you doesn't itself constitute a crime. The other definitions, I think, are what you would expect them to be. Obviously, we have social media, which is why this bill is needed. Page 3, lines 21 to 23, states that it limits the application of this bill to a person 18 years of age or older. And you may wonder why that is. And the idea is that we currently have a separate statute dealing with sexting that was passed a few years ago, dealing with those under 18. And so that's why we have that age limitation. Moving on to page 4. Currently, as drafted, there are just 2 elements of this crime, or would be 2 elements of this crime. Page 4, lines 2 and 3, disseminates an intimate image of another person is the first element. And then the second element would be, starting with line 5 through line 8, knew or should have known that the depicted person had a reasonable expectation that the image would remain private and the depicted person did not expressly give consent for the image's dissemination. And I apologize for the ungrammatical nature of the way this is done, because we have the present tense on line 2 of disseminates, but then in Romanet 2 on line 5, it's new past tense. So the committee may want to wordsmith that to make it grammatically correct. There's in going through this, one policy question for you, the committee, to decide is whether you want to add a third element, the mens rea element. Do you want to have a certain state of mind? And it's been proposed by others. And indeed, in my first draft of this bill, I did have a mens rea element. I've emailed to the members of the committee a proposed Romanet 3, which would go on line 9. And if memory serves me, it would read intending to humiliate, harass, harm, coerce, or threaten another is the proposed amendment. And I leave that to the committee to decide whether you want that amendment or not. The virtue of having that amendment would be that you typically in crimes, as we had a long discussion during our last session virtually, typically in crimes, there are 2 components of a crime. There's the voluntary act, the reus, actus reus, and there's the mental intent element, the mens rea. So this would fill in the mens rea portion of it. One, if you do not adopt the proposed amendment that would add an intent element, then you may want to consider creating a law enforcement and legal proceedings exception, because if you think through the mechanics of this, if you have a report of this incident, the officer arrives, the officer has to gather the image, the officer then has to send it to the prosecutor, the county attorney, right? And so if you don't have some intent element, then the officer, him or herself would be committing a crime. And then the county attorney would have to give it to the defense counsel, also committing a crime. So you either need to create that exception, or you can have the mens rea element, or you could do both. So I leave it to the committee. You'll also note this is a plain vanilla version of this statute. Parts of it were modeled in part from Arizona's version of this. You'll notice that on page 4, lines 10 through 13, this is a misdemeanor, punishable by not more than 6 months imprisonment, a fine of not more than $1,000, or both. So it's a policy choice for you to decide what the penalty should be. The reason that I wanted this drafted as a misdemeanor is that I'm reluctant to create new felonies, as it tends to cause additional burden onto the county attorney system, the justice system, both in terms of public defenders, the county attorneys, and the court system. However, you may reasonably believe that for a second offense, maybe it should be stepped up to a felony. Perhaps that might be, I'm not recommending that necessarily, but a reasonable person could certainly do that. And with that, Mr. Chairman, I would stand for any questions.
Committee, questions for Representative Stiff? Kay, do we have that amendment that Representative Stiff is referencing?
And Mr. Chairman, I believe I drafted that amendment in the present tense so that it says intending to. You may want to wordsmith that so that it all flows the way it should.
Sorry, Representative Stiff, can you say that again?
Mr. Chairman.
The tense is going to be off on this as well.
Because the tense matches the first Romanet disseminates, which is in the present tense, but the second Romanet is past tense. So
which one do you want?
it doesn't matter to me. Mr. Chairman, as I don't think it changes the meaning either way. Mr. Chairman, I might add this mens rea element is taken mostly from Arizona's version of the statute. However, I made one change. I added in the word humiliate. And the purpose of that is to account for the potential situation where, for example, the jilted ex-lover may be in possession of an image from that person's ex and might show it to his or her friends in an attempt to humiliate the ex romantic partner without that person even knowing. And so humiliate wouldn't require that the victim know that it's happening. Whereas I think harass, threaten, coerce requires that the victim implies that the victim knows. So so the addition of the word humiliate is a different sort of an addition that I haven't seen in other statutes, but I thought made sense.
In Representative Stiff, the key being the mens rea of intending or the intent to do one of the following actions, right? So, and I guess this doesn't apply because right now the bill exempts out if you're under 18. Is that right? But if I were a naive 19-year-old and I had certain said photographs and I showed them to my friends in the football huddle after practice, if I didn't intend to do one of these things, humiliate, harm, harass, threaten, or coerce the subject of the photos, I wouldn't be guilty of this crime.
Mr.
Just
Chairman,
by showing the photo to somebody.
Mr. Chairman, if the amendment is adopted, that would be correct.
Without the amendment, Representative Stiff, if I were that same football player and I showed the picture to my friends in the huddle, I would be guilty of this crime.
Mr. Chairman, that's correct.
Okay. That's it. Vice Chairman Washit.
Thank you, Mr. Chairman. Representative Stiff. Nothing by passing this law would prevent a blackmail charge if the elements were provable. True?
Mr. Chairman, Representative Washit, that's right. This doesn't change the law of blackmail, which exists and has been on the books for a very long time.
Representative Stiff, we had a bit of a discussion about this off the record, but can you elaborate on the years of age? Are you familiar enough with the sexting laws to elaborate on whether we need this provision on page 3 to not apply to underage or to minors?
Mr. Chairman, thank you. To be honest, I've not recently reviewed the sexting statute that does apply to minors, but I believe the idea is that bill, which became law, was crafted to deal with the different considerations you have with juveniles, but it applies to essentially the same conduct.
So leaving the provision in on page 3, a person 18 years of age or older, leaving it in if we're comfortable that the law is at least similar, there's no consequence. If we were to remove that provision, not knowing exactly not having the sexting law in front of us, the only risk we would run is someone under 18 could be charged with 2 different offenses, which would not be uncommon in our criminal world, and which usually induces a plea bargain and seems to be a common practice. Would you agree?
Mr. Chairman, that's correct. I don't frankly have strong feelings about whether lines 21 through 23 on page 3, well, I should say it this way. The age restriction in line 21, if you were to delete that, I don't think you would be doing a lot of public harm. I think it's reasonable to have that age restriction just so that you don't create this overlapping patchwork quilt of having minors sort of subject to 2 different sets of laws, whereas adults are only subject to 1. So I think it's simpler to leave it in, but if were you to delete it, that could also be a reasonable choice.
Otherwise, it could be confusing, like drinking. Can I drink or can I not drink until I'm 21? Can I disseminate images or not disseminate images? Committee questions for Representative Stith? Representative Yan.
Thank you, Mr. Chairman. Representative Stitt, thanks for the bill. I'm curious on whether this would include a situation where, let's say I have, or an individual has media from a previous relationship and they're hurting for money and they decide to just sell it and not necessarily intending to harm. There might not be an intent to harm. So even if we had this mens rea element in, would this cover a situation where I just wanted to make money off of old stuff that I had?
Representative Stith.
Mr. Chairman, Representative Yen, that's a great question. So in the event where someone's using it for commercial exploitation, if they're doing it without the consent of the person, then it seems that in the proposed amendment, if you added, well, without the amendment of mens rea, it would clearly violate the statute. With the proposed amendment, you would be, if you're doing it without the consent, it seems that a prosecutor would be able to prove that that constitutes harming the person. That is, if a person's intimate images are being published without their consent, it would seem that establishing harm would be pretty straightforward. That also raises a copyright issue too, I suppose, that is part of federal law, that someone could say, hey, that picture is, I have a copyright in that image. But that copyright issue is not dealt with here in this bill.
You good, Representative Yan? Representative Provenza.
Gotta wait for the green light. Thank you, Mr. Chairman. And thank you, Representative Stith. I am wondering if you know of or have any understanding of how these statutes in other states stand up to First Amendment challenges and what that looks like.
Representative Stith.
Mr. Chairman, Representative Provenza, I'm not aware of a successful First Amendment challenge to a statute structured as this one is, as this bill is. It's an interesting overlay. The First Amendment free speech rights, what's interesting about them is that they're not absolute rights, of course, that that the government has a legitimate interest in establishing time, place, and manner restrictions. And this would be I suppose, be a content-based prior restraint. That's true. So it's an interesting issue. To be honest, I don't know. I'm not aware of a successful First Amendment challenge being made. Certainly, the lack of the consent of the person seems to be the key linchpin that I would think would preserve the constitutionality of the bill. I would think if someone consensually says you can distribute this image anywhere you want, then it seems like a person would have free speech rights at that point to disseminate the image. But I wish I were more of a First Amendment scholar. I apologize.
Representative Provenza, follow up? No? Okay. Well, thank you for almost opining on the First Amendment for us, Representative Seth. I thought we were going to get there. Further questions, committee? Oh, yes, please, Representative Oakley.
Chairman Olson, Representative Stith, I'm not sure this is specifically a question directed towards you, but talking about the drafting. Just noting, so B says a person 18 years of age or older is guilty of the offense of disseminating an intimate image if the person, one, disseminates an intimate image of a person. I just think, whether it's redundancy or I don't know specifically if perhaps, if we're just outlining the elements of the crime, we just stick with, if we're going to, and I see no reason not to from what you've said, but 18 years of age or older does the elements of the crime rather than outlining it twice in a row there.
Mr. Chairman,
Representative
Representative Oakley, as I read it, I see the intent on on line 22 of page 3, when it uses the phrase, the offense of disseminating an intimate image is sort of naming what the crime is.
Sure.
And that it becomes the designation of serves as a naming function. And then when you go over onto page 4, you have lines 2 and 3, you're saying what are the elements, what's the conduct that constitutes this offense that we've now named. But it doesn't have to have a name. If you
Yeah,
want.
thank you.
I suppose if on line 3, you wanted to merely say that a person is guilty of an offense and have an unnamed offense, you could delete those words on page 3 if you wanted to.
Sure.
I think as it stands, I think it's a little easier to read in the sense that if a prosecutor were creating the charging document, count 1 might be offense of disseminating an intimate image.
Well,
But perhaps I've misunderstood your question.
Representative Oakley.
thank you, Chairman. Well, I mean, when you're looking at statutes, they have a title. So I'm just looking at, thinking of the statute book, unlawful dissemination of an intimate image, then it goes into the elements 2 lines later, then it says what the title is, which then repeats it in the first element. I would submit that 3 in a row, which is what it would be since it is entitled, is a little redundant. Do I think it matters? Not really, but anyway, I didn't know if you had a specific belief that it needed to be there.
Yeah. Mr. Chairman, Representative Oakley, it may be a bit wordy, and if you can make it more concise, I encourage the committee to do so.
Vice Chairman Washit.
Hey, Mr. Chairman, back to the proposed possible amendment and the good chairman's football huddle scenario. If the intent were to sexually arouse the other players as opposed to humiliate or harm the person depicted in the image, would that be a defense?
Representative Stith, the
Mr.
sexual arousal defense.
Mr. Chairman, Representative Washit, I believe that would be a creative defense that someone might pursue if the amendment is limited to that. So the committee may want to, if you wanted to expand this proposed amendment to include, sexual gratification of another or others, you could do that, I suppose. I guess in drafting this, I think of the sort of the typical scenario where the person's doing it essentially out of malice or out of jealousy or hurt feelings, and that's their motive. But the world is a variegated place, and so all sorts of different things can happen.
Yeah, I think that's right, Representative Stith. Whatever the, magic actions are, I don't necessarily know. To me, the most important part is that it has some identifying mens rea, so that we could create this list to be whatever it is. But I think we don't want to capture. We always want to be cautious not to capture the innocent actor or actors in this particular scenario. I think the amendment probably would probably cover 90% of most scenarios. Representative Oakley.
Thank you, Chairman Olson, Representative Stith. So, and maybe for discussion, if we were to stick with the mens rea, which I actually, I know you've mentioned it could make it more difficult to prosecute, and as a prosecutor, but I'm okay with that. I think the good chairman just said, it's never trying to get accidental or innocent conduct, if you will. So personally, I would support the addition that you've added with intending to humiliate, harm, harass, threaten, or of course another. What I am thinking in response to Representative Washat's comments, perhaps we add another a subsection that would be an alternative with the intent for sexual gratification or arousal of the actor or others or something. But where we included that, so it still has the intent, but it's not a defense that you were trying to share it for your high school buddies, or well, I guess high school is not going to be it, is it? We'll ditch that, your college fraternity, whatever it may be. Maybe we include that. What are your thoughts on that?
Mr.
Or
Chairman,
sorority, just to be completely equitable. Representative Stith.
Chairman Olson, Representative Oakley. And I'm just sort of thinking out loud now. If you, in response to Representative Washat's comment, if you wanted to edit an alternate state of mind as described, you could do that, but I think I think to capture Representative Washat's example, you'd want to focus on the sexual arousal or gratification of others, not the person who merely possesses it, because otherwise you'll make it a crime if you have an existing, let's imagine you have an existing romantic couple, they're getting along fine. One sends an intimate image to the other, and then without the other's knowledge or consent, that person in possession of it uses it for his or her own sexual gratification or arousal. I don't think most people would think of that as a crime. So I think there's some challenges to having a sexual arousal state of mind that's going to work. But certainly if you want to say, if someone's displaying it, in a movie theater without the person's consent, that would seem to be an act that we'd want to make criminal. So I think you'd want, if you put in a sexual arousal state of, intent element as a possible state of mind that would warrant prosecution under this, I think you need to focus on third parties being the target of that. Does that answer your question?
Representative Oakley.
Thank you, Chairman Olson, Representative Stith, but wouldn't the other elements cover that? I mean, this is specifically disseminating an information or disseminating an intimate image where somebody, there's an and in there, knew or should have known that the image would remain private and the person did not give consent for dissemination. So I don't see us catching, that's a broad net that catches consensual activities. Because
Mr.
if
Chairman,
it did,
Representative
we'd
Oakley.
probably be there in other ways.
Mr. Chairman, Representative Oakley, I agree.
Representative Zwanenser.
Thank you, Mr. Chairman. Sorry for the weird question. When we're talking about intimate parts, would I be correct that if you show someone's backside, male or female, that would not be included? Basically, how I read the bill, you either have to display a sexual act or the intimate parts, one or the other, and perhaps an implied sexual act, which gets interesting. If there are no imminent or intimate parts, then somehow the photo or the image or the video, whatever it is, has to reasonably imply that a sexual act is happening. So my question is, though, we would include, if it's not a sexual act and it's just an intimate image and it's a part, the entire front of a female is covered in the below the waist part of a male, but neither the backside of a male or female is covered under that definition. So if I wanted to post, if somebody else wanted to post pictures of people's backsides, not covered under this bill. Would that be correct?
Representative Stiff?
Mr. Chairman, I believe as drafted, that's correct.
Committee? Nope. Anything else for us, Representative Stiff?
Mr. Chairman, no, thank you very much.
Well, you're going to stick around because I'm sure this conversation is going to keep going.
Thank you.
Thanks. Okay. I know at some point I had the possibility of a representative of the Attorney General's office testifying. I don't believe I do have currently anyone from the Attorney General's office. Is that anyone from the Attorney General's office? No. All right. Anyone from any agencies? Any agencies? I can't imagine there'd be, I guess, DCI. Nope. All right. Well, we'll just open it up to some more general public comment then. I'm going to start with in the virtual world. I have Ms. Murr from I believe the Domestic Violence and Sexual Assault Coalition would like to testify. Let's bring her in. Hi, Tara. If you want to light up your camera and unmute, and there you go. Introduce yourself, please, and then give us your comments.
Thank you, Chairman Olson. Good afternoon, and committee members. Thank you for having me on. My name is Tara Muir. I am the Public Policy Director for the Wyoming Coalition Against Domestic Violence and Sexual Assault. While I don't practice in the courtroom, I do have a law degree, just FYI. I do want to take a moment to introduce my organization to the new representatives on this committee who I haven't chatted with yet, and then speak briefly in support of this bill as written and offer a thought or two to make it even better. I'll be very brief. Our coalition is a nonprofit advocacy and education member organization. We are not a government agency. There is a similar coalition like us in every state and in many tribal nations as well. Our coalition's role here in the legislature is to support survivors if they are here to testify. Whether they've worked with us or not, we're here to support them. Our largest role, though, is to represent survivors' interests across the state because not all victims or survivors are the same. There are many myths and stereotypes about victims and survivors. And I would add, as we talk about showing the picture to the football huddle, a lot of myths and stereotypes about the perpetrators as well. We want to make sure public policy is broad enough to help all victims and survivors. And mostly we want public policy to do no further harm with unintended consequences. Victims have been through enough. We do also represent our member programs. Generally, there's one in each county and the Wind River Reservation. The programs are funded primarily through the Attorney General's Division of Victim Services Office through both state and federal funds. The staff at these programs can easily answer questions for you just as I can. And if you need help finding them, just let me know. I'll get you connected. We're here today to support House Bill 85 as it's been drafted, the unlawful dissemination of an intimate image. We want to thank Representatives Stith and Baker and the other co-sponsors who brought it. We hear from many survivors across the state that intimate images referenced in this bill may or may not be or have started out consensual, but distributing them to friends and families or posting them in social media is rarely, if ever, consensual. Regardless of how that intimate image was originally created, the later sharing of it without the person's consent should clearly be a crime in Wyoming. And this bill at this point offers clarity and definitions to assist prosecutors. Our thoughts on this bill is to suggest that the threat of sharing the image you might also want that to be a crime. It would be a great addition to the bill, as that is often the way abusive people maintain control over their victims. Usually it's a threat that's used to coerce a person to stay in a relationship with an intimate partner, and that relationship may already be violent and abusive. It's also a way for a rapist to somehow hint that a victim of a violent rape could not have possibly have happened the rape could not have happened given the consensual nature of what a picture might depict. So it's just some food for thought for you all. We understand that this is a coercive tactic of an abuser is sometimes hard to prove. However, once victims are seen as credible witnesses, it may not be so hard to prove that along with other credible evidence. Given the harsh penalties, there's another bill down the hall that was just sent to general file. There were pretty harsh penalties in that, particularly with a subsequent offense, and we would support that. We support other options in the other bill down the hall as well, because we are concerned about societal problems associated with mass incarceration. We appreciate the work this body has done on criminal justice reform in the past and continues to do. We want to see more restorative justice that actually helps perpetrators stop their awful behaviors, not less. So the bill down the hall, this was the Voyeurism Bill. I hope I'm not breaching any conduct by mentioning it, but they added that a court may order supervised probation as a penalty and sex offender treatment as well, because we want to get those perpetrators past this bad behavior. I think I'll just mention quickly, because Representative Stith is bringing the mens rea amendment, that the impact on the victim is really what's important here. And we have to get past that myths and stereotype that all young men or men alone are innocently showing this intimate image around to either the people in the football huddle or anywhere. It's the impact that is the problem here. And it feeds into that stereotype that any person who sort of accidentally shows it perhaps, or says, I didn't mean anything by it, will never get charged. So it's a policy question for you as the committee, but we would certainly support that the mens rea piece stay out. And just to address, Representative Provenza asked about First Amendment issues. And I don't have all the details, but I do know there was an Illinois case that I'm not sure if it got granted certiorari with the United States Supreme Court, but the lower court certainly ruled that this kind of law does not regulate speech on matters of public concern, but only speech involving purely private matters. So it did not violate any free speech concerns. And with that, I've taken long enough and I'm happy to take any questions. Thank you.
Thank you, Ms. Muir. Questions, committee? Representative Yin.
Thank you, Mr. Chairman. Ms. Muir, thanks as always. So my question would become, I think my biggest worry with the mens rea portion is that it could deter victims from coming forward. Do you know if that happens in other places that have pieces like this in their version? And do you know if there's anything that we can do to make sure that people come forward and feel comfortable coming forward when stuff like this happens? Thank you, Mr. Chairman.
Ms. Muir.
Mr. Chairman, great question, Representative Yin. I have not heard anything from that angle, at least in Wyoming. I'm more than happy to do a little looking into that with our colleagues across the country and see what the unintended consequences of that might be, because I agree, if people don't want to come forward, that's a problem. But it is also clear that many victims will never come forward, no matter what, no matter how light the sentence. They don't need this on the front page, right? But I'm happy to look into that and get back with you on that too.
Further questions for Ms. Muir? Representative Provenza.
Thank you, Mr. Chairman, and thank you, Ms. Muir. You mentioned restorative justice or rehabilitative justice in terms of trying to deal with the core problem, right? Why did this person share this media in the first place, and how can we help them and not wanting to conduct themselves in that way in the future? Do you know of any programs or any anything that already exists in which we could potentially use that in sentencing rather than perhaps jail time? Thank you.
Ms. Miller?
Thank you, Chairman. Thank you, Representative Provenza. Other than the ones I suggested, maybe it's a supervised probation. So if you violate that, then we're going to give you a stiffer sentence, the usual things that we have in our state. Sex offender management might only fit some scenarios that come before the court. Other remedies, other restorative justice, they're still too early in their programming, especially in other cities, other locales. But certainly if there's a sort of a sex offender piece to this, and I'd love to have the Department of Corrections weigh in on their sex offender treatment and how that actually works. That could be a great way to address these crimes. I think if we really step back and we really want to be preventive and restorative, it's really a different topic about helping young people in our state, whether that's through school or not, understand what healthy relationships are and what you do and don't do to hurt each other, and what isn't a crime, especially about boundaries and the big one, capital C, consent. What does that look like? And why would you want to go and do anything, especially in this intimate relationship category, that would hurt that other person so much? I'm always looking out for new programs and what could be something we could try in Wyoming. And if there's something specific to this kind of crime we're talking today, I will certainly let you know if I come upon that and do some more work on that for you.
You good, Representative, or you have follow-up, Representative Provenza?
No, Mr. Chairman, thank you.
Okay, thank you. Thank you, Ms. Miller, for your testimony and for your comments. Always enjoy having you participate in the Judiciary Committee meetings. So look forward to seeing you throughout the rest of the session.
Thank you, Chairman.
Let's go ahead and bring Mr. Lehman in, Clarissa. Okay, Mr. Lehman, yep.
Thank you, Mr. Chairman, members of the committee. I certainly don't have the wealth of knowledge that the former speaker just gave, but I'm sorry. My name is Mike Lehman. I represent the Diocese of Cheyenne, and just wanted to let you know that we do stand in support of this bill and appreciate the work of the entire committee. We know that as technology has developed in this area, it's a lot of work to keep pace. There's a lot of good that comes from our technology, obviously, and there's some difficult areas that need to be looked at. So just want to stand in support and appreciate the work that's being done. With that, I would stand.
Thank you, Mr. Lehman. Seeing no other hands out in my virtual world, if any pop up, we can circle back, but let's go ahead and move to the room. Former Representative Winters, also a former distinguished member of the Judiciary Committee and a former vice chairman as well of this committee. We should be so lucky to have so many vice chairmen in the room. We have 4 if you count Representative Yin.
What? Well, Mr. Chairman, I feel lucky just to be here in these wonderful new digs that you guys have. I think it's beautiful. I just want to stand here. I'm now the executive director of the Family Policy Alliance of Wyoming, and we stand in general and broad support of protecting privacy and sexual intimacy, which is what this bill covers. And so I just want to offer that as general and broad support from the group called Family Policy Alliance of Wyoming. And with that, I would stand for any questions.
Questions for the Honorable Winters? Nathan, do you have any opinion on the mens rea amendment?
Mr. Chairman, thank you so much for giving me the opportunity just to briefly talk on that idea. Establishing one's state of mind, I think, is very important, oftentimes as we talk about law. And I believe it will allow for a little more judicial discretion. I think that is a robust conversation, and it's important to balance civil liberties, of course, with this important subject. And so I'm thankful that you guys have picked up that part of the conversation and are discussing it.
Appreciate you. Thank you. Okay, Jody, want to come on up?
Thank you, Mr. Chairman. Members of the committee, my name is Jody Levin. I'm here on behalf of Charter Communications. Charter is neutral on the bill. If all of you don't know who Charter is a cable operating company in the state of Wyoming. Charter's concerns really, Mr. Chairman, and I should back up. I did email the committee an amendment. If everyone does not have that amendment, I do have hard copies. So if anyone would like that, please just let me know. Charter's concerns are on page 4 in subsection D. We greatly appreciate the language that makes it clear that this act is not construed to impose criminal liability on the service provider. So my client is essentially like the mail carrier. You get a sealed envelope, you have no idea what the contents are, you just deliver it from point A to point B. The concern that my client has raised is that while it's clear that you are not to be criminally liable, could you be civilly liable? And so the amendment they have asked me to propose to you today would be on page 4, line 16, to strike criminal, and then after liability, insert, comma, criminal or otherwise, comma. I did visit with Representative Stith about this amendment. He did ask if there was a situation ever where under 47 USC 230, my client would feel that they did not have broad immunity. In doing some research on this issue, the Communications Decency Act was passed in 1996. So much has changed in the communications world since 1996. And at one point in time, Section 230 did offer broad immunity, but that is now being tested somewhat in the courts. So since my client would have no fault of their own, they would have no idea that they just transferred an image from point A to point B. They would ask that they also be, or the service providers also be immune from civil liability. With that, Mr. Chairman, I'll stand for any questions.
Jody, given your final comments, then I suppose you have your client would have a position then on the mens rea. I mean, you just said that disseminating image, your client may disseminate images and not have knowledge that it's even disseminating the images. So the inclusion of the mens rea element to require an intent would certainly provide complete protection to your clients. If they disseminated the image and had no intent or had no knowledge that they had done it, they certainly would have no intent that they did it. So would you agree on that? I mean, that would you agree that the mens rea alone would provide that protection? And then if so, would this amendment actually be necessary, do you think?
Chairman Olson, what I think you would hear from my client is that what that would do is then open up an entire new opportunity for cases to be filed to try to determine whether or not a carrier knew. Truly, the carrier has no knowledge. They don't police these networks. There are certainly platforms where that kind of policing does occur, but this is, you could also think of it as a pipe. It's, you would take similar to like water from point A to point B, like a utility. So when you have no knowledge of what is in the packet that you are transferring, the question is, why would the state of Wyoming want to make you liable for that?
And I assume your client is primarily concerned with the civil liability, then I can't imagine an actual concern with a misdemeanor offense as a corporation. Couldn't spend time in jail. I don't think.
Mr. Chairman, I think that the intent of this bill is to really go after the perpetrator. Who is harming another person? The carrier, the service provider isn't the entity that's truly harming another entity. What has happened in other states, though, is, and this is often why we end up having to bring some of these issues forward, is that somebody did go after the service provider because that is a wealthier recovery of damages.
Representative Zwanzer?
Thank you, Mr. Chairman. It's rare I have fundamental disagreements with Ms. Levin, but and I guess my concern, and maybe the question I'm asking, is where she's putting criminal or otherwise in the statute in this bill, because this would say any liability, criminal otherwise, on every type, right? So not just your telecom services, but your information services, your interactive computer service. And I think that's pretty broad blanket immunity. I'm trying to make sure I don't say anything inappropriate on camera, but there are services, or I guess what I would say is an interactive computer service, right? Where in today's adult entertainment industry world, there is advertising of secret videos, or people don't know that the camera's watching them, and some of these services can amplify that and use that for promotion. And if one of these happened, right, where you're unlawfully disseminating an image you shouldn't be, and all of a sudden it goes to some site or I hate to call it an information service, but let's say an interactive computer service that then promotes that, I don't think I'm comfortable saying they have blanket immunity, certainly maybe criminal, but I think that's a very big step to insert in what I co-sponsored as a simple, specific bill. And I would wonder if Ms. Levin has any thoughts on if perhaps we could amend the otherwise blanket immunity to specifically a telecommunications service for charter communications, not charter cable.
Ms. Levin?
Chairman Olson, Representative Zwanitzer, there's a reason why I'm often never before the Judiciary Committee, and I'm often in the Corporations Committee or Revenue, because that is the world that I understand so much better than this one. So I think the challenge that gets pointed out here is how much the industry has changed since 1996. And there certainly are elements of the communications industry that are the social media platforms are ones where if an image is out there, you can actually look at it, police it, and you can have policies to take it down. The difference is the kinds of services that we talk about in this bill, the telecommunication services, are services that you wouldn't have that knowledge of content. And if I have to work with Representative Stith in the committee to try to better craft an amendment, I'm happy to do that. We don't want to stand in the way of this bill. We certainly understand that there are victims and they are hurting and that there is a need. My client is just worried that when somebody is in one of these situations, who do they go after? Do they go after the perpetrator who harmed them, or do they go after a major corporation? And that's the issue that we're trying to resolve.
Representative Oakley?
Thank you, Chairman. Good afternoon. Is it Levin?
It's Levin, yes.
I just have a question. You said that that somebody went after, was it the charter?
Mr. Chairman, Representative Oakley, it was not my client specifically.
Okay, and I guess my question, what I'm trying to get at here is, in what forum that they were quote unquote gone after, and specifically what I'm getting at is, this is Title VI. So what we're talking about is criminal by definition. So I guess my thought is, even if that needs addressed, it needs addressed someplace else. This is about criminal law, criminal liability, Title VI. So if you have any thoughts on that.
Chairman Olson, Representative Oakley, this is an issue that I actually talked at length with my client about, that this is the criminal statute. They felt that there isn't just an ambiguity that arises when you are specifically carved out from criminal liability. Does that leave open the question of civil liability? And Mr. Chairman and Representative Oakley, I am not an attorney, so you can probably already tell I'm woefully uneducated in a lot of these matters to respond to some of these questions. And I do apologize in that regard.
No, thank you, Ms. Lynn.
We would need to find the common law tort of unlawful dissemination of an intimate image, which is probably too progressive for the common law of Wyoming, but could be out there somewhere. Committee, further questions for Ms. Levin?
Thank you,
Okay.
Mr. Chairman.
Thank you, Ms. Levin. We may circle back when we're considering amendments, so don't hesitate to stick around. And for not your
Absolutely.
first time in judiciary, just been a long time.
It's been a long time, Mr. Chairman.
We invite you to hang around and enjoy it some more. It's far more enjoyable than corporations, but then again, I'm biased. All right, Ms. Lewis.
Mr. Chairman, members of the committee, my name is Laura Lewis, and I am here today on behalf of the Motion Picture Association, and we are here to express our support for Representative Stith's amendment, as it is critical for the operations of legitimate news organizations. As you can imagine, in the gathering and reporting of news, there are circumstances when the depiction of an image that contains nudity stands to have historical or educational relevance. Some examples could be images from the Holocaust or the Pulitzer Prize winning image titled Napalm Girl. And in these circumstances, with the language proposed in the amendment, then these news organizations would be excluded from the scope of the bill. So we are very appreciative of the bill sponsors' efforts in bringing this language. One small recommendation for a change would be in the last word of the amendment, another, to perhaps replace it with the words, the person depicted in the image, just to more specifically focus on the person whose privacy is being violated, which I think was part of some of the examples we cited earlier. So with that, I stand for questions.
Committee? Vice Chairman Washit.
Thank you, Mr. Chairman. Appreciate you being here today. My thought was, as a father, might I be put in an awkward position if someone's threatening to disseminate a picture of my child or somebody else that I'm close with? So I wouldn't necessarily be the one depicted in the image, but I might be the one who's being harmed or humiliated by the threat and dissemination. That's why I'd be cautious about your suggested amendment.
Mr. Chairman, Representative Washit. Yes, it's a suggestion, but if certainly the intent of the committee is to be more broad, that is fine.
Ms. Lewis, do you feel as drafted, does it provide the protection that your client is interested in and not being captured within the statute unintentionally?
Mr. Chairman, the way it is drafted, it is consistent with similar intent language in most other states. And so we do believe it does capture. Certainly the word harm is less defined. So, you know, it does perhaps become more broad. But we still are comfortable that it captures our goal.
We can't define all the words too narrowly. We'll put all the lawyers out of business out there, and
Would
heaven
not do
forbid
that.
we do that. Further questions for Ms. Lewis? Oh, Representative Oakley.
Thank you, Chairman Olson. Good afternoon, Ms. Lewis. Really quickly, just if the intent to humiliate, harass, if some of those weren't added, do is it your belief or assertion then that your clients would be or do knowingly and or should have known that the person had a reasonable expectation, a lot of times reasonable expectation of privacy, but the reasonable expectation that the image would remain private. And then of course, and they didn't give their consent. So is it your testimony, your thought that without this, that conduct is something that you do or is done on a regular basis or something, that specific part of it, that a reasonable expectation on the behalf of the person of whose it is that's private, that you disseminate those?
Mr.
Ms. Lewis.
Chairman, Representative Oakley, I don't know specifically. I know part of the concern is, and I think it was cited earlier by the bill sponsor, for instance, the state of Arizona, when they lacked this intent language. Shortly after the passage of the statute, a group of booksellers filed suit against the state for fear of their own vulnerabilities. And it's my understanding the state did not defend the statute in that case. And subsequently, the legislature came in and I think in 2016, then revised and incorporated intent language. And so I just, on behalf of my client and the information I've been given, it was more to ensure consistency with other states and avoid some of the pitfalls that some of the earlier passages experienced.
You good?
I'm good. Thank you, Mr. Chair.
Thank you, Ms. Lewis.
Thank you.
Further questions for Ms. Lewis?
Thank you.
Thank you. Further testimony on House Bill 85. And seeing no further testimony on House Bill 85, I'll go ahead and close public comment at this time. Committee, what is your pleasure? Representative Zornitzer?
Mr. Chairman, I would move House Bill 85.
House Bill 85 has been moved by Representative Zornitzer and seconded by Vice Chairman Washit. Amendments? A pile of them here. Or not, or no amendments, of course. Representative Zornitzer.
Mr. Chairman, I would move the proposed amendment that Representative Stith brought that includes the Romanet 3 intending to humiliate, harm, harass, threaten, or coerce another. I do think that provides more clarity to what the intention of the bill is. But at the end of the day, anything we do in this area is better than what we have. And so I do think this focuses it more, but really does address the harm that's being caused, that we have what I would argue is a gap in our laws.
Seconded by Representative Williams. Representative Zornitzer, you didn't want to move the cleanup at the top? Or are you good with the cleanup language at the top too?
Oh,
Just
Mr.
on
Chairman, the
dissemination.
entire amendment.
Okay.
Before you.
Okay, so the entire amendment, okay, good. Discussion on the amendment, Representative Yen.
Thank you, Mr. Chairman. So I think regarding the situation I presented to Representative Stith regarding making money, I'm not entirely sure, and maybe some of the lawyers in the room can help me, if that you could necessarily prove intent to harm in that situation where you just want to make money because you're broke. And so in my opinion, I think I would trust prosecutorial discretion, and maybe the prosecutor in the room can help me on how she feels about that. Instead of requiring a mens rea for this particular crime. That's my opinion. Thank you, Mr. Chairman.
Representative Oakley. What say you?
Thank you, Mr. Chair, Representative Yin. Sometimes it's sort of difficult, I guess, to discuss, but harm means exactly what a jury says it means. So that's where prosecutorial discretion does come in. And, it's interesting. I mean, are we opening, if we added the word profit to this list? I mean, are we opening a can of worms? And so, I mean, I think, yes, you could prosecute and say that they intended to harm them. And then it would be a defense attorney and a jury that would have to acquit, saying that wasn't their intent. That's a valid defense. And or if you're interested in that, again, we could discuss adding the word profit to this list, that somebody, well, let's see, intending to, no, that doesn't work, to profit from, or maybe that's anyway, a whole different discussion. Is that something we want to discuss adding, making it criminal to profit from the dissemination of? Perhaps that's a different bill.
Does that make you more comfortable, Representative? Representative Crago?
I would propose a friendly amendment to Representative Zwanitzer amendment, which would be to make all of them past tense. Elements 1, 2, and 3. So disseminates would become disseminated. 2 is new or should have known, that's already in past tense. And then 3 would be intended to rather than intending to.
Representative Zwanitzer, you don't teach English, but you play an English teacher sometimes.
I do sometimes. I'm just excited that Representative Crago told me it was friendly before I got to agree, but I do think it is. So it's friendly to me if it's friendly to the co-sponsor. My second.
Is it friendly, Representative Williams?
It's friendly.
We like friendly amendments. And that, I'm not tracking, but we when we were cleaning up the tense, now we are in line with the tense as well, that we were cleaning up in the bill previously.
I believe so, Mr. Chairman.
This bill has interesting tense.
Yeah.
You feel good? Okay. Feel better? All right.
Excuse me, Mr. Chairman.
Yeah. Oh.
Could
yes,
you
Kay.
repeat the corrections you made to this last
To
amendment?
Representative Crago?
Yes, sir. Thank you, Mr. Chairman. On line 2 on page 4, disseminates becomes disseminated. So we replace an S with a D. And then on the, and I don't have it up in front of me, but on the amendment proposed by Representative Stith, intending becomes intended.
Thank you.
You bet. Committee, further discussion on the amendment? Question being called on the amendment. All those in favor of the amendment signify by raising your hand. All those opposed? That amendment's been adopted. Further amendments? Vice Chairman Washit.
Thank you, Mr. Chairman. I don't have the verbiage, so I'm going to try and bring a committee of the whole amendment to address the sexual arousal defense. But in the interest of time, I think we can dispense with that for now.
You want to, if you want to try it, you can bring it.
You can read your writing.
Representative Oakley.
Thank you, Mr. Chair. It would be unfortunate if we didn't get something done because of my messy handwriting. So I would move or to make an amendment. So it would be an additional one to this, an alternative, I suppose. So if we did it, yeah, a Romanet 4, if that was 3. So well, I'm just looking at the language we have intended. Anyway, I've got with intent for, intended for sexual gratification or arousal. And then, do you think it should be of self or others or both? Of the person or others?
That's it.
Yes.
Seconded by Vice Chairman Washit. And Kay, don't worry if once this amendment goes through, what I'll do is I'll just have Representative Oakley get with you after and make sure you've got it precise. Okay,
Thank you.
you bet. Is everyone or discussion on the amendment? Representative Craigo?
Yes, Mr. Chairman. So I'm just curious how it's going to line up with the previous 3 subsections. How will it exactly read?
Representative Oakley?
Thank you, Chairman Olson. I guess what I would look at is, you know, it needs to be in the alternative, either the intent to what we've just passed, intent to harm, humiliate, harass, or intent for sexual gratification. So
adding the conjunction or?
yes, between these two. You're right, it does need to be separate because the way we've got it written now, let's say without it. So 1, 2, and 3 with that intent. So it needs to be 1, 2, and 3 or 4 as far as that third element.
Does that help, Representative Craigo?
Thank you, Mr. Chairman. So I would suggest we put it in part 3 and just put an or in between.
Yes, there you go. That's it. That's exactly it. You're right. I knew it was there somewhere.
Okay,
That would be much cleaner.
I like that.
Excuse me, Mr. Chairman, could we have page number and line numbers?
We will, when we're all done, I think it'll just be easier. She'll hand it over to you. It'll be easier.
Thank you.
Yeah, but it is page 4, line 9. Any other discussion, Representative Craigo?
Thank you, Mr. Chairman. Can you read me the language one more time, please?
Representative Oakley?
Mr. Chair, Representative Craigo, yes, and certainly any discussion or cleanup. I had so the dissemination intended for sexual gratification or arousal of the person or others. And again, I don't know if the person of, you know, I'm trying to get of the self of the perpetrator, of self or others. What are your thoughts?
Representative Craigo?
Well, I was just thinking we could kill 2 birds with 1 stone and cover the situation addressed by Representative Yin. And I think that actually does that. But I would say the person disseminating the image and or others.
Would you agree, Representative Oakley and Vice Chairman Washit, that is a friendly amendment to the amendment?
Chairman?
Yep.
Since by definition, I don't know that we need to say, I don't know if self is what we want to say, but the person disseminating, because by definition, this whole thing is addressing that person. Right? I mean, if they're, or whoever's being charged, all of these apply to them, disseminating, knowing, intending.
Representative
Mr. Chairman, this isn't really my level of expertise. I don't know a lot about this, but it seems to me like you could be talking about the person in the Picture.
Yeah, I don't mind. So, but just say again, what I guess, I'm not sure I'm understanding. If you
So
could
at the
just-
very end of your, so if you read it again, I'll tell you exactly where I'm talking.
Okay, intended for sexual gratification or arousal of,
The person disseminating the image and or others.
okay.
Friendly enough
Sure.
that we
Yes.
don't have to have an amendment on the amendment? Okay. Representative Yin?
Mr. Chairman, my only question is with our rules of statutory construction is and or something that we need, or should we just put it as or? That's it.
Okay.
Here.
He's worried about statutory construction and or.
Mr. Chairman, it's
You
not a
need
big
the
deal
or-
either way.
You need the or.
I'm sure LSO can fix it either way.
Yes, between these two different intents, I would say yes.
Representative Craigo?
Mr. Chairman, I believe what Representative Yin is saying, we don't need the word and, we
That is
just need the
implied.
word or.
Oh, you
And I
do
believe
not
he's-
need the word.
I believe he's correct.
I thought we only had the word or anyway. I'm confused now. Read the current amendment that we have scribbled down.
Well, I guess I'm not sure what you're asking. We have and in there at this point, just because that's the amendment brought by Representative Stiff, but I agree we would take it out here now since we're adding 3 or 4. That's why we
Oh, I
didn't
see.
have
Yeah.
it. Do you
no,
see?
Yep. I'm
So I
tracking
agree,
now.
I agree with both.
I guess I was doing that without saying in my head. Okay. Representative Craigo?
Mr. Chairman, thank you. So this is my fault because I used the word and or, and that's what Representative Yin is talking about at the end of Representative Oakley's amendment.
Okay.
That's what he's talking about, not the and between subsection 2 and subsection 3.
Okay.
Sorry.
Representative Yin, if your intent was to confuse the chairman, you properly did that. Okay, Representative Provenza.
Thank you, Mr. Chairman. I just want to make sure I'm understanding all of this correctly. So we're in the mens rea of having the intending to humiliate, we're adding sexual arousal, and then we're ending this sentence between threaten or coerce others. Would this allow for us to go after someone for disseminating information under, say, trying to sexually arouse others without the intent of humiliating? I'm just making sure I'm clear because there's a lot of back and forth on words.
Vice Chairman Washut, would you arrest someone
I don't arrest anybody
anymore?
I think the clerk, what I was picturing in my mind was that we weren't putting this sexual arousal language in front of coerce another, but rather after. That we're going to add an or and then include the sexual arousal language.
Representative Provenza?
Thank you, Mr. Chairman. Yeah, that clears it up. I missed one of the backflips we were doing.
Representative Zwanitzer.
Thanks. I just need someone to clearly state the amendment for me before we vote.
Yep.
Whenever we're there.
Okay. Feel like we might be getting close. Representative Oakley? Maybe one more time?
Thank you, Mr. Chair. I will try to
Okay.
read my writing. So it would be subsection 4. Didn't we have 3 before?
Going from 3.
We already did 3.
But where this is part of.
Oh,
3
I
now,
see.
think.
Or, you're right. Okay.
Yep.
So or intended for sexual gratification or arousal of the person disseminating the image or others.
Representative Zwanitzer.
Thanks. Question, how do you prove the sexual arousal of others? If you're going to bring them in and say, were you sexually aroused by this photo or are you disturbed? I don't understand. That's where I couldn't understand.
Representative Oakley, as a prosecutor, what type of evidence would you present to prove sexual arousal in this scenario?
Mr. Chair, I think that's interesting. First of all, there can be circumstantial evidence, but I'm not kidding. The point wouldn't be about proving that somehow who was aroused at what moment. Using examples that have been used, it would be if that was the intent of the dissemination to be used in that manner, which is a different focus than our other intent, which is the intent to purposely harm the victim, if you will. So I do think we're getting somewhere with when the intent is, and forgive me if this sounds sexist, focusing on men, but when it is passed around, let's say, using the example of a group of men, with that being the intent behind it. Again, is there room for a defense that wasn't what it was or that didn't happen? Sure. And that's part of the law. I mean, I think that's acceptable, but I do think we're getting the intent of what we're trying to hit here. Perhaps I'm wrong.
So,
Representative.
yeah, so Representative Oakley, as stereotypically wrong as the football huddle example may be, we've got the football huddle, we've got the individuals, the one who disseminated the photos. You ask him if he's dumb enough to take the stand. He doesn't plead the fifth. He takes the stand. You ask him, "But why'd you even show this image?" And he says, "Because I thought my buddy would like it." And that's probably enough. But I guess you wouldn't need the criminal defendant to testify. You could ask somebody else in the huddle. Why do you have any idea why your friend, well, he knows that I like these types of images or something like that?
Mr. Chair, yes, any of these where we want to have it, obviously, in any criminal prosecution so that we've got enough evidence beyond a reasonable doubt. But again, believe it or not, when intent can be inferred. I mean, that is enough. I can tell that to a jury and I can take it to a jury that this was the intent and it was the intent. And of course, when we use narrow examples, it would be certainly much more fleshed out in front of a jury if that's what we were bringing or in front of a judge. And certainly if we're to that level, then there would be evidence that was what the intent was.
But to back it up this is an or, so the prosecutor, you could prove either one. This may
Yes.
be your last ditch effort element that you may even go to, because all you got to do is prove that he intended to harm, harass, humiliate, threaten, or coerce someone you don't even have to go to that element if you don't want to, because it's an or.
Yes, it's a different element completely.
Vice Chairman Washington.
Thank you, Mr. Chairman. For what it's worth, I believe in our indecent exposure laws, there was also an element of sexual arousal or gratification. So it's not like this is unique to this law, that in other circumstances, we have to prove sexual arousal as an element of the crime.
Representative Yin, the idea here was to help you out with I think the scenario you were troubled with. Do you feel like we're helping at all, or?
Mr. Chairman, yes, I do think it would cover the case that I presented earlier. I would also offer a friendly amendment if that would be okay on a better construction.
I like friendly amendments because they require less procedure.
Okay, so I would offer a friendly amendment to the amendment sponsor to instead of the construction set earlier, on page 4, line 9, it would be little Romanet 3, intended, capital A, to humiliate, harm, harass, threaten, or coerce another, semicolon, or capital B, for sexual gratification or arousal of the person or others disseminating the image. sorry, for sexual gratification or arousal of the person disseminating the image or others, yeah. So we break the
I don't think I have.
Whoops.
Sorry.
The mics automatically redo this.
Depending on where we get.
Okay, I
Get all the
don't.
way through second reading. So we
You want me to run up and get one?
much final file.
Well, Albert just sent.
I'll take care of it. All the mics come on automatically.
The mics are on, by the way.
Mics are on? No, he told me that, all mics. Turn your mics off. All mics. Hey, Clarissa, can you hear me?
Hi, Mr. Chairman, I can hear you.
All right, committee. Call us back to report or to order. I don't have a gavel. We lost, Clarissa, we lost the digital world for a few minutes, it looks like. But we're good now. All right, we're back. Just in time for House Bill 33, Representative Stith. It's a long day with the Judiciary Committee. We appreciate you.
Mr. Chairman, always a pleasure.
Walk us through this bill.
So House Bill 33 was a bill that this committee, that the Joint Judiciary Committee worked on over the interim. I was part of a subcommittee group that dealt with this issue. And I think we worked in good cooperation with all the stakeholders, with the Contractors Association, and with the, I think, with the county commissioners and the municipalities. Essentially, this bill, outlaws conduct that probably most of us thought was already a crime in Wyoming. So the purpose of this is to fill a gap, close another loophole, essentially. And the situation that arises is, to make this a concrete example, the problem we're trying to solve is that if you have a municipality that is bidding for a public works project, whether it's to build a street or a water treatment plant or something, it may be a complex enough project that they want to have a mandatory pre-bid meeting. That is, you want to say, all of you contractors, we don't want you to make a mistake in your bid. We want you to understand the specifications of the project. So we're going to have a meeting. We all get together. And if you don't attend this meeting, then you can't bid. So 3 contractors show up. Wyoming is a sparsely populated place. We don't have a lot of contractors. So 3 contractors show up. They have their mandatory pre-bid meeting. When those 3 contractors or bidders walk out of the room, they all know each other's identities. And so there's this temptation for them to get together and just talk about, well, who's going to be the general contractor? Who's going to be the subcontractor on this? And it can and does happen that you may have 3 bidders showing up at the mandatory pre-bid meeting, but when it comes time for actual bid day, only one of them actually submits a bid. They're the low bidder because they were the only bidder. And then lo and behold, the 2 others get hired on as subcontractors, right? And so then you have a project where the engineer's estimate for the project was, say, $4 million, but the only bid was $4.8 million. And so what happens to that extra $800,000? Well, who suffers? The taxpayers suffer. And that $800,000 essentially gets split up between the other bidders. So sort of a long-winded example, but that's the kind of potential collusive bidding that this bill is designed to avoid. Now, if for background context, it's the case that it's already against federal law to do that. It violates Section 2 of the Clayton Act. As a practical matter, our U.S. Attorney's Office in Cheyenne is busy, and I'm not aware of a prosecution brought under the statute in my memory. I'm just not aware of one. Maybe they did one. So what the bill does is effectively, it has the heart of the bill, from my point of view, is on page 4, starting with line 16. And it creates a new section 6-5-402 called bid rigging. And so lines 18 and following provide that a person commits bid rigging when he knowingly conspires with any other person who is or would be a competitor to any submitted or not submitted bid to a governmental entity with the intent that the bids submitted or not submitted will result in the award of a public contract to the person or to another person and the person. And then they have a couple of requirements. Over on page 5, Romanet 1 provides the other person or receives from the other person information concerning the price or material term, that is, they're sharing their prices. Or on line 8, page 5, Romanet 2 submits a bid that is of such price or other material term that he does not intend the bid to be accepted. That is, they can conspire to submit an artificially high bid. That is, they get together ahead of time and say, okay, you be the low bidder and we'll submit high bids to make it look like this was a legitimate process, when in fact it's a conspiracy to essentially defraud the taxpayer. So this bill is designed to save taxpayer money by having more competitive bidding, and frankly to protect honest bidders, honest contractors. Page 5, the next section deals with bid rotating. I think that's sort of a less common occurrence. I'm not really aware of a situation where I've heard of that happening here, but it would happen where you have a lot of contracts. So for theoretically speaking, you might have a division, frankly, within the state who does a certain kind of project over and over again, similar kinds of work, say putting grout into mine voids, for example, and there's only 3 qualified bidders, and they sort of rotate the bids amongst themselves. I think it's a less common, and I might just add generally that I don't think you have to believe that bid rigging is happening all day, every day, in order for this to be a good idea. Finally, the somewhat trickier provisions start on page 6 when you're talking about what the government employees can do. The idea here, generally speaking, is that you want the process to have integrity so that sealed bids remain sealed. You want to have a process so that the public servant is not opening a bid and disclosing it early and then disclosing the contents of that bid to another bidder so that they get a leg up, for example. Finally, over on page 9, starting on line 8, section 6-5-406, that makes kickbacks illegal. Essentially, if you say, well, if you hire us, we'll give you a vacation in Cabo San Lucas for free, say, if you select us as the contractor for the job. So on page 9, for their beginning at lines 13 and then through 17, this outlaws kickbacks both by the person who gives it and the person who receives it. So, which I think creates a symmetry there. Page 11, 6-5-407 would be created to outlaw bribery. The structure of this statute was borrowed largely from Illinois, which has a similar statute. With respect to the specific penalties, fines, and how you classify it, I don't have that. That was largely borrowed from Illinois. You may decide that you want to, instead of making it a felony, make it a misdemeanor, or make it a felony with a 2-year instead of a 5-year penalty. Those would all be policy decisions for the committee to make. The Association of General Contractors had one proposed amendment that I think is a really good idea. It was on this sheet. I don't know if that was distributed to you, but it cleans up. I'll have to get the page and line number here.
Okay, do you have physical amendments, or did we already have them?
So, for example, the first proposed amendment would be on page 7, lines 8 and 9. And so what the amendment does is it says that a public servant, if that person gets a call by a prospective bidder and the bidder's got a question about the drawings, the city engineer, for example, doesn't have to just hang up the phone and not talk to the bidder. They can say, you have a question about sheet 7, specification 8, about whether this is supposed to be a wall made out of concrete or a wall made out of wood and plaster, for example, or drywall. If that is information that would be made generally available to the public, it's not a secret what the specifications are, for example, then the city engineer can say, oh yeah, this is a framed wall. This is not a concrete wall. And that serves, so the idea is we don't want to outlaw useful communications because there's no public purpose in having the bidders not understanding what they're bidding on. So what this amendment does is it clarifies that the public servant can talk to the bidder and disclose such information if that disclosure would be otherwise available to the public upon request. In other words, it doesn't, whereas the current language mistakenly says, well, if we didn't already post it that this is a framed wall, not a concrete wall, then I can't tell you, right? So it's a very slight change in wording, but I think it's a good one. That's page 7, lines 8 and 9. And then the similar at the bottom of page 7, line 23, replaces the word information would influence the likelihood of acceptance with the phrase, the information is intended to influence. And I think, again, the idea is we don't want to create hair triggers for felonies. We want to make sure that, or I guess a misdemeanor in that case, that we don't want to create a hair trigger for committing a crime. We want someone to be intending to be doing something bad, right? The other amendment appears on page 8, line 7 and 8, has the same wordsmithing to replace information is made generally available to the public, and the proposed amendment replaces it with information that would otherwise be made available to the public upon request. So I think those are good. And then finally, there's an identical conforming amendment on page 9 saying replacing the words is also made available to the public with would otherwise be made available to the public upon request. And again, those are cleanups just so we don't artificially restrict the flow of information from, say, the city engineer to a prospective bidder about information that, you know, the bidders may need to know. So with that, Mr. Chairman, I would stand for any questions.
Who's planning on testifying? Testimony greater than or less? Less than. Out there, sorry. My mic wasn't lit. Out there in the virtual world, we have, I think we possibly have some folks who want to testify. If you want to raise your virtual hand to let me know if you want to testify. I'm just trying to get a count to see how far we can get it through this bill. Possibly one.
Mr. Chairman,
Yeah, Clarissa.
I believe YDOT also was available for questions for this bill. Would you like me to bring them in?
Well, I'm trying to get an idea of how much testimony I have to see if we can get through this bill. And I kind of feel like we might be able to. So, yeah, let's go ahead, Clarissa. Let's bring in, why don't you just bring in everyone in the virtual world who wants to testify? Bring them all in at once and I will figure out what I'm going to do here. So we got YDOT. And okay. Mr. Brubaker.
Mr. Chairman.
Yep. So why don't you go ahead and introduce yourself, and then you're from the Airports Coalition?
That's correct, Mr. Chairman. My name is Devin Brubaker. I am the Secretary for the Wyoming Airports Coalition and currently serve as the Airport Director for the Southwest Wyoming Regional Airport in Rock Springs. Today, we stand before you trying to come to the table with solutions. We've been working on this bill for several weeks, looking for a way to improve the language to make it acceptable to our membership. We take great pride in bringing solutions to the table. However, this bill offers several concerns that we've struggled to understand and the problem, and also struggled to understand the problem that is trying to be solved. While there are several concerns with this legislation, one of the main issues lies with the definition of public contract found on page 3, as well as the language found on page 8, beginning on line 18. We understand the intent of this section is to be making it a felony for any public servant to award a public contract based on something other than the selection criteria which were disseminated prior to the procurement. However, our interpretation of this bill results in an unintended effect of this subsection. Our interpretation of this section requires all units of state and local government to create and disseminate selection criteria prior to entering into any public contract for the procurement of any and all goods and services. Because the term public contract is so broad, this would require all units of government to develop criteria for award prior to signing any type of contract for goods or services, even those which need not be bid or otherwise subject to competition. This section is broad enough to require the development and use of criteria prior to executing an invoice, which could be considered a public contract to procure office supplies, add a phone line, apply for a credit card, or sign a license agreement to add computer software. These are all items which under current Wyoming law need not necessarily be subject to any competitive procurement process. To address these concerns related to this specific issue, we have created 2 potential amendments for the committee to consider and choose from. The first would be a potential
Mr.
amendment.
Brubaker, did you supply those amendments to the committee?
I believe, Mr. Chairman, some committee members may have those. Our public advocacy firm is in attendance as well and may have those to distribute. Lori Urbakite or Sherlyn Kaiser. So, Mr. Chairman, the first potential.
I'm sorry, hold on, Mr. Brubaker. Do we have copies of the amendments? Mr. Brubaker, I think my mic was off, so I didn't address the virtual world as I intended to, but I was trying to figure out, so it's 2:00 now and we have second reading, which is second reading. I was trying to figure out how much testimony we would have. Took a straw poll of under 5 minutes, but in my mind, that meant that it was simply we support or we don't support. I guess I didn't expect that we would be receiving multiple amendments. So what I'm actually just going to do is we'll finish up with you, Mr. Brubaker, but I think I'm actually going to hold this bill back and move it over to another meeting. Maybe, I'm sorry, I didn't have my mic lit, so I couldn't get comment from you in the virtual world, and maybe that was more difficult, but I was intending to survey the public as to whether this was just simply a we support or don't support quick testimony, and I'm not trying to cut your testimony short. Certainly want to hear from you. So if we have, it sounds like we actually have extensive testimony on this. I don't think it's as clear cut. So why don't you finish up in under a minute, Mr. Brubaker, and then we'll probably end with you and we'll circle back at a later time.
All right, Mr. Chairman. So I believe what was just distributed is a copy of some proposed language for page 3, line 14. After the word law, we would insert the words, for the purpose of this act, public contract does not include the purchase of emergency supplies or services, consumable products not bought in bulk, or de minimis goods and services which are not subject to competitive procurement processes under Wyoming statutes. Since we developed that amendment, Mr. Chairman, we also have a second option before you that we do not have in writing, but it mimics existing language in this legislation found under section 404 on page 7, lines 11 and 12. The second option could be to replicate that language found on page 7, lines 11 and 12 in section 405 in a new subsection D. So those are our two amendments that they both achieve what we think we need to do to fix this bill, to make it somewhat palatable. But Mr. Chairman, committee members, while we ask for your favorable consideration of one of those two amendments, we continue to stand against the bill, as we largely feel this bill is really a hammer looking for a nail. And it even respectively with Representative Stith's testimony and presentation of the bill, you could hear that there some of these situations haven't even existed. So we're out there trying to solve a problem that doesn't exist today.
All right, Mr. Brubaker, appreciate that. And I only have one amendment, even though you're talking about two. So laying back the bill will provide you enough time to get that other amendment into writing and provide it to the committee so that we can consider both, which I think you would appreciate.
Absolutely, Mr. Chairman, and we'll be prepared to testify at the next committee meeting as well.
Perfect. So we'll probably just pick up where you left off. That way you can present us with your second amendment. All right, so that being the case, we have already noticed our meeting for Wednesday. So we may see this continuation Thursday. So you'll see a formal notice go out, but that's kind of what I'm thinking. And that way we can gather the remainder of the testimony, and I don't want to shortcut, this pile of amendments that we have here. So let's work through it all, especially if we've got, we got all the stakeholders in the room, which is what we want. We got everyone here. If we can figure out a consensus on what makes it work, then I think that'd be the legislative preference. So let's try to see if we can do that at the next meeting. All right, we are adjourned.